right, good afternoon, everybody. Thank you for joining us this afternoon for our Wills versus Trusts Showdown. My name is Carol Anderson. I am the Marketing Director here at Generations Law Group. And we have an ebook that goes really nicely with this presentation. And that is our How a Trust Can Help You and Your Family. So I'm going to put a link to that in the chat box, and it will link you to all of our ebooks. And you can choose the trust ebook, and feel free to download any of the other ebooks that are of interest to you. We have many different topics and they're all free, so feel free to download those. Phil Summers is our presenter today, and he is our probate specialist here at Generations Law Group. He's going to answer our questions about wills and trusts and which one is better, which one's better for me. And we will get started. And Phil, I'm going to let you take it away.
Terrific. Welcome, everyone, this afternoon. I'm going to talk about will or trust-based estate plans. So there's really two basic approaches. One isn't better than the other, but they have advantages and disadvantages. So I want to take you through kind of what a will-based plan is, what a trust-based plan, and then kind of give you some things that I've seen in the probate court. When things hit the probate court, that usually means, or particular litigation, things didn't go well or as intended. So, but let me go through it. We'll hopefully that'll help you decide what is best for you. So let's jump to the next page. So let's talk a little bit about probate. We hear about probate. What is probate? So I guess the definition of it is really it's the court proceedings. But one way to look at probate, you're taking an asset that's titled in the decedent's name and decedent's name alone, and trying to change it to somebody else. And how do we do that? Obviously, the will helps give us instructions. If there's no will, then you died what's called by intestate. So then the laws of the Commonwealth of Massachusetts. Probate is a very slow process. In Massachusetts, you have to keep the estate open for 1 full year by statute, which is an issue that we'll talk a little bit more about it. But if your family needs the money immediately, or the people are your intended beneficiaries of your estate, that could be a problem because it's not, you may not have quick access to the money, or anything else part of the estate. Now, another thing we should think about is also taxes, because there are taxes associated with probate, and also when the person dies, there could be an estate tax in Massachusetts. Well, there is an estate tax. That's for any estates that are above $2 million in assets. It was recently raised from $1 million at the beginning. It was retroactive at the beginning of last year. And there's also could be income taxes. Even though the decedent may have died mid-year, you're still income taxes that may be required. If the estate earns money, perhaps from investments during the pendency of the probate, there could be what's called fiduciary returns that are due, and also could be property taxes. So there's a lot of different possible estate taxes. Remember, estate taxes are when someone dies, the taxes are paid at the estate level. So typically, the money is provided to the beneficiaries tax-free, as long as the taxes are paid at the estate level. We can go to the next slide, please. So I get this question a lot. What is in your estate? And then I guess you have to think about, you have to define what your estate is. There's the probatable estate and there's the taxable estate. Let's talk about probate. So things that have to go through probate. If a piece of property, your house, is titled in your name, it would have to go through probate. Bank accounts, if they're just in your name, they have to go through probate. Any other assets they're solely titled in your name has to go through probate. If it's jointly held, then by operation of law, the surviving joint tenant gets the property. So if you own your house with your spouse, upon your passing, it would automatically go to your spouse and not through probate, which is good news. Bank accounts, if they're jointly held or if they have named beneficiaries, those items would avoid probate. So a probatable estate is just assets that go through the probate court. Your taxable estate is much different. A lot more items are in it. So it's the property you own, your investments, money, checking accounts, life insurance proceeds, and also personal property. So if you have a collection of very expensive paintings or perhaps a baseball card collection, that's your taxable estate, which may not have to go through probate. If we can go to the next slide, please, Carol. So, when we talk about estate planning, you should really think about how you should really reflect your values of what's important to you. Is it, making sure your surviving spouse is taken care of? There's enough money there. Or maybe you want to leave a legacy to your children or grandchildren, pay for their college education or charitable giving. Other goals of estate planning is to minimize estate taxes or to protect the assets from mass health or mass health liens down the road. So you can have a number of goals. You can have multiple goals with your with how you craft your estate plan. Quick story: we had a client once. The mother and father had a very long-term marriage, 50 years. Unfortunately, the wife passed away when the father actually remarried, and then he passed on roughly 5 years after that. Short-term marriage, but in that time he had changed his will at the behest of his new wife and cut out all the prior children out of the will. So you have to think, is this a result or an outcome that the mother who passed first would have wanted? With a will-based plan, they can be changed. So unfortunately, there was really nothing that could be done. The father was competent at the time. That's how the courts viewed it. Although we don't like the outcome, everyone has a right to give their money to whom they want and when. They can't be forced to, even if decisions we don't like. In this instance, it seems it was incongruent to what would have been a disposition that the mother and father would have wanted for the children. So remember, there are goals of planning, but you need to remember to make sure the safeguards are in place for your assets, your lifelong assets go where you want them to go. So next slide, please, Carol. So typically when we have an estate plan, we want to make sure we think of these goals, but some other goals. But estate planning is really saying to whom I want, where I want it, and when I want it. It's funny, when I'm in the probate court, I can't tell you how many times, typically it's the kids are fighting over family, and you really see kind of a microcosm of kind of the family dysfunction in the probate court. But I can't tell you how many times the judge has just said, it's not your money. It's your father's, your mother's money, and it's their decision, not yours. So sometimes we don't like the will, or maybe we have a will contest, but it's at the end of the day, it's you gets to control where you want your money and to make sure you meet your goals. Some of the other things you need to think about is you want to make sure in terms of estate planning that if you're incapacitated. Now, a last will and testament only takes effect when you pass, but there's other things you need to think about. If you become incapacitated for any reason, you can't make your own decisions. You want to make sure you can have someone who can step into your shoes, be able to make healthcare decisions, financial decisions. Sometimes you want to have as part of our goals, we want to make sure maybe we have a special needs child. We want to set up a trust, or we have a child that is not good with money, or maybe they have a spouse that we don't like and we don't think that marriage is going to last. So we want to set up the estate plan that makes sure we protect our children that may need a little help, or helpfully protect the money for it's not going to go where we don't want it to go. Remember, any inheritance your son or daughter receives would be split half. It could be split half with the ex-daughter or son-in-law. Another goal of estate planning is to minimize estate tax. Now, again, Massachusetts, we're a threshold state, so anything over 2 million is taxed. So you can set up trusts where it will carve out, particularly in a husband and wife, where we can carve out the full tax up to the 2 million exemption on the first to die, and reduce the taxable estate for the second to die. So I can talk a little bit more about that later, but there's certain goals in terms of eliminating the Massachusetts estate tax. There's also a federal, which I believe is around 12 million. So you have to be over that to implicate it. Estate taxes in Massachusetts between 6 to 16%. Most of our clients fall in the 8 to 10% range. The other thing when we counsel clients is really talking about passing on your values, your goals. Many parents, many families, maybe it's education, maybe it's certain charities that they feel very close to and they want to continue. So these are just some of the things that you want to think about as you craft your estate plan. Next slide, please, Carol. All right, so let's talk about the last will and testament. Now, as I mentioned earlier, it's only effective at your death. It's really a contract. It's based on contract. It's one way to look at it, a last will and testament, is an instruction sheet. It's a playbook as to how you want your estate distributed after your death. It tells us who gets what. It tells us who will be managing the estate. It's called a personal representative, by the way. It used to be called an executor or executrix. Massachusetts changed that term about 7 or 8 years ago to be more consistent with the rest of the country. But if you hear the term personal representative, that's how we refer to the person who manages your estate. Also, a last will typically detail, if you have minor children, who will be the guardian, who will make decisions for your children. Wills can be simple. I give everything to my spouse and then to my kids, or I give everything to my spouse and my spouse gives everything to me. We call those I love you wills. We give you this, and it's very straightforward. Or they can be very complex depending on your needs. Maybe specific items or bequests go to certain people. Charitable bequest. Holding money in an estate for an extended period of time. For example, when you have a child who's a minor, they obviously can't manage the money. But also maybe you have a child that, again, as I mentioned earlier, that's not good money. It's what we call a spendthrift trust, that we keep the money in the trust. We have a trustee who manages a trust. This is created through the will. And they have discretion in terms of allowing money to be dispersed. So some considerations based on your family, what you're trying to accomplish, and also your family dynamics. Wills typically are fairly low cost versus trust. Just give you an example of the not having a will, or let me clear up a misconception. People think as well, I don't need a will because if I die, everything goes to my spouse and vice versa. That is not true. And I can tell you one sad case of one in Maynard where a father had abandoned the family. The son had married, had a couple children. He tragically died very early. So when we are probating his estate, he did not have a will. So when you don't have a will, as I mentioned earlier, you die intestate, which means the laws of the Commonwealth take over. They determine who gets what. And in this case, and the way the laws are worked, statutes in Massachusetts, is the wife got the first 100,000, and then she got half of the rest. And the next heir was the father, and he did get a portion of the estate. And he had abandoned the family, had no limited contact for 20 years. It was a horrific situation, but this is an example of what happens when you don't plan. And it's just a horrible, horrible outcome. the judge's hands are tied. These are the intestate laws in Massachusetts. And so the father, who had no contact, actually walked away with money that could be much more used and needed by the widow and her children. Next slide, please, Carol. Let's talk about the risk of a will-based plan. Again, it only takes effect if someone dies. It doesn't help to control assets while a person is still alive, or if they become incapacitated or incompetent. Those are your healthcare proxies, your powers of attorney, but a will does not have that. If you own properties in multiple states, then you may likely have to have probates or ancillary probates in other states. For example, we have clients that may, they're residents of Massachusetts, they have a house up in Hampshire or in Maine on the shore. If the house is in the decedent's name, you'll likely have to do an ancillary probate in New Hampshire or Maine, also with a primary probate in Massachusetts. Wills do not, they tell you where you want assets to go, but it doesn't provide any long-term planning considerations. Example, someone who has special needs, spendthrift, asset protection, a will doesn't offer those advantages. This is where it goes. It's the instruction sheet, the playbook. This is where things go. Another client story, we had a sister, they're sisters. One of the sisters passed away. They're quite elderly, I believe in the late 80s. Unfortunately, the decedent never updated her will. I think it was 30 plus years old, where her sister was receiving a large portion of her inheritance. The problem was the person who was receiving the inheritance, she was in a nursing home on state assistance. So because the plan wasn't updated, reviewed, modified to the kind of the current problems or the current issues, the money actually went to the state. It did not go to the sister. Had they done a little bit of planning or the right planning, they could have created a trust, to improve the sister who was in the nursing home for quality of life. Some incidentals, maybe TV, some things that would make her life a little bit easier, or things that she may want to, that were not covered by mass health payments. So very limited in terms of the will-based planning. It didn't incorporate that type of looking ahead, and also it really has limitations of providing for current needs. So it really didn't protect the asset. Carol, next slide, please. Okay, let's talk about trust. So we talked about wills, the benefits, why we should have one, and also some of the limitations. But let's talk about trust. And when we talk about trust, there's so many different, I call it's like ice cream flavors. There are so many different. You have vanilla, chocolate, so many different types. Irrevocable, Medicaid trust. Lots of different trusts with different purposes. But I guess when you kind of boil it down to the essence of what a trust is, it's really a private document between you, your trustees. Now, the trustee manages the asset and the beneficiaries. Now, that person could be the grantor, who actually creates the trust, who actually funds it with the assets. All those three people could be the same person. What's nice about a trust is you get the assets immediately. You avoid the probate court. Now, the probate court, one thing I didn't mention, and one of the negative things that are negative about it, is a very public process. So if you have a nosy neighbor, if you do a probate filing, they can go look in what's in the estate. They can find out property, financial assets, a lot of information, who's getting what. We've had cases where we're about to make a distribution in the probate court to intended beneficiary or devisee. That's a person who's named in a will, and the creditors swoop in at the last minute to put a claim on it. So trust is different. It's a private document. It's not part of the probate court. It's based on contract law. Now, in trust, you can keep control over the trust through your lifetime. There's certain trust that you can change it, you can amend it. And you can also put language in there that if should you become disabled, you're incompetent, the trust will give your family members or your loved ones kind of instructions how your affairs will be managed. And so that's one of the advantages of trust. Your loved ones can have access immediately to your funds. You avoid probate and the expense of probate in the public process. So, Carol, if we can jump to the next one, that'd be great. Let's talk about some of the other advantages of a trust. So certainly you can control distributions to your descendants. Let me give you an example of family, young family. You don't want to, if something should happen to you, and if you're married, your spouse is the same, and oftentimes you don't want the money to go to your children immediately, especially if they're of minor age, or maybe they're, young adulthood, but may not have the maturity to handle it. In those situations, if kids get the money immediately in a will, we call it the Harley Davidson money because they immediately go out and buy a Harley Davidson. May not be the right approach. In a trust, we can set it up that we can control the distributions. We can have a trustee manage the distributions. We can put certain language in that can be released at certain stages, like maybe for education, healthcare reasons, maybe for rent and certain, important things in life, but it's not to go on a trip down the Caribbean. So a trustee can oversee distributions of the asset. We call it the HEMS standards: health, education, maintenance, and support. You can also have money put into a trust for the lifetime of the beneficiary. So if there's a special needs or you really don't think the child can handle the money, you can have that kind of the strings attached to make sure that the money is used for appropriate things. A lot of clients we have, they'll maybe put language in a trust where education and other items are paid for, but maybe you get half at age 25, another half at age 30. But again, if it's a revocable trust, these things can be changed. And also you can put certain ways we can carve the trust and create a discretionary trust that, if you're concerned about your child's choice in marriage, so to speak, and you don't want to go to the ex-daughter-in-law or son-in-law, you can certainly have a trust that can certainly accomplish that goal as well. Carol, the next chart, please. So we talked, the kind of a big classification. There's two, when you get down to it, it's two big types of trust. Revocable trust and irrevocable or irrevocable trust. Let's talk a little about revocable trust. Again, one of the main benefits of a revocable trust, you avoid probate. The cost, the time delay, the public nature of it. It goes to your intended beneficiaries immediately. It's a great way to save on estate taxes. This used to be a larger issue, but Massachusetts raised the threshold from $1 million to $2 million recently. So it doesn't implicate as many families. But if you're over that $2 million mark, you can certainly, particularly with couples, you can carve out the estate for the first to die, and then when the estate tax is due on the second to die, the size of the estate's a lot smaller. You may actually even avoid estate taxes. Remember, estate taxes, if they are due, are not paid on the first to die in a couple. It's always on the second to die. As I mentioned earlier, very easy to amend. You are in control of revocable trust. It actually runs under your Social Security number. You can change and amend it. If you decide to change the beneficiaries, you can do that. You can change the trustee. You can be the trustee. The big downside of revocable trust, it does not protect you from any mass health liens. So you need asset protection. This is not the trust. It does not give you any protection at all, or from creditors. Next slide, please, Carol. Irrevocable trust is different. So again, it avoids probate, but the way I explain an irrevocable trust, consider it a steel box. As you see the picture here, it has a lock on the front of it. So you put the asset in this box. Now it's protected from creditors, mass health, if it's written the proper way, but it's also protected from you because once you put it in there, you don't have access to that. Now you can become, you receive the income from that trust, but it's a way to take an asset out of your estate. For example, life insurance proceeds can be put in there, a house. So certain things you can put in there that you can put in that irrevocable trust, and you get that protection. Now, as I mentioned, there is that big issue of loss of control. Revocable trust, you can be the trustee. This right here, irrevocable. No, if you want that protection from a mass health lien, you can't be the trustee nor the beneficiary. When the distributions are made from it. It's also subject to the mass health 5-year look back. So assets you put in there, the clock is running. So you have to make it through 5 years in order to avoid any mass health be able to reach that, grab that, claw back that asset. Next slide, please, Carol. So trust can have you can put provisions in there to take care of your spouse, significant other people, charities. You can time the distributions. You can take care of minor children. So there's really a lot of advantages with a trust. It can also put in your personal values to a considerable extent. I had a client recently. She was a dog lover. She had several trust charities that she set up. That she wanted her estate to go to, as well as setting up a pet trust, believe it or not, to take care of her beloved dog. Very legal in Massachusetts. In Massachusetts, you can't give your estate directly to a pet. You have to go through a pet trust and have a trustee manage the money. And it wasn't a lot of money going to the trust, but it was something to take care of for the pet because she dearly loved that pet and really had a lot of enjoyment having that pet. So certainly trusts you can save money on in the long term. You can minimize or avoid probate. Again, probate is very expensive. Just to file a probate case is $409 filing fee. And that's just the beginning of it. You have to publish to the newspaper. You have to account to the court. Trust, you don't have to do that. It's private. As I mentioned, there are other types of trusts. There's a pet trust. There's also gun trusts you can set up. There's special ways to handle guns. So a gun trust, would actually own the guns. It would have a named beneficiary and also kind of the roadmap how those guns are provided to the intended beneficiary. Next slide, please. So to the big question and why we're here. Which one is better for you? And like any good attorney, they'll say, well, it depends. It really does depend on what's your current plan, what your heirs and beneficiaries, what your asset protection, who you're trying to protect things for, how quickly your intended beneficiaries need to obtain the resources. If you're concerned about a nosy neighbor or a creditor of your child, again, that's a downside of the certainly of wills. Trust can also ensure it goes to where you intended. So particularly on second marriages, we find that we have seen issues with that. So where there's been a long-term marriage, sadly, one of the spouses passes, remarriage, the example I told you earlier. When you can always change your will, trust, depending how it's written, you may not be able to change it. So if you want certain assets to go to your children from the first marriage, a trust would be a better vehicle for you to do that, to ensure it goes where you intended. Another issue is there family harmony in your family. If a will, again, is open, is public, it's subject to contest, will contest, capacity issues. Trust, again, you avoid that. Look at the problems of some of the famous people who have died, in the last several years. Aretha Franklin, she had a handwritten will, which is very surprising. The singer Prince had no will. And they've been litigating that case for over 5 years, still going on, because there's absolutely no planning. And everyone's fighting of who's getting what. What did the person want? What did the decedent? You're always trying to figure out, and this is what the courts is trying to do. What did the decedent? Who do they want the person to get the money? Now, in the absence of any evidence or any will, they're gonna default to the intestate laws of Massachusetts, and sometimes we have some horrible consequences or outcomes, when that happens. Now, just think about that. If you don't plan, it's a plan to fail, as I like to say. You possibly set up your family for, a dispute, some issues, problems I've seen in the past where, a parent will say, well, my son and daughter never got along, so maybe I'll just make them co-PRs, and maybe this will bring them together, or co-trustees. I have very rarely seen that be successful. Usually it leads to more fights. With a will, I've seen other people, for ridiculous reasons, want to litigate. We had one client, we didn't take the case, but the person wanted to litigate, contest the will, which, because it's a public process, you can, because she wasn't given the toaster, the beloved toaster from her mother. And it was those things like that can really delay and really exacerbate any family disharmony. So things to need to consider, but at the end of the day, we're trying to accomplish your goals. What do you want done? It's your money. You've worked hard for it. These are lifelong assets. What are you trying to do with them? And then you try to figure out what's the best vehicle to accomplish that. So with that, I think that's it. I think that's the last slide. Yeah, which is the winner? To be determined. There's no clear-cut winner. It depends. It depends on what's important to you and some of the things that I've talked about. If you have any questions, feel free to call us. We're with Generations Law Group. We have offices in Acton, Sudbury, and Andover. We're about to open up. Carol, thank you very much.
Thank you, everybody, for joining us, and thank you, Phil, for sharing your knowledge and time with us. And have a great afternoon, everybody.